hotly contested rules. It took us a little longer to get to a stopping place. So, thank you all for being patient. Judge Mello, welcome.
And welcome to you, Senator.
All right. So our goal today is to dive into the work that we started last time and on our recommendations. And I think we have minutes as the third thing on our agenda, so I think we'll stick with that schedule unless anyone wants to change it. All right. So, the first thing I would ask is, as you've been going through the comments that we've received in our past meetings, do you have any additional suggestions to make to add to the list of recommendations?
Senator Lyons, Madam Chair, is Chris Recchi. Maybe I could just apologize first of all for having to miss the last meeting we had, because that was unfortunate. I got called away. But I'm going to ask Jeff. Sorry to do this to you, but we as an exercise, we were going to go back through the Energy Generation Siting Commission report and see if there was anything new there that was not captured in Board Member Cheney's comments. Jeff, I'll just ask you if you found anything.
I only had time for a very cursory look, and nothing kind of jumped out at me that had been missed.
Okay, because I definitely recognize some of the things, but I wanted to look at that. So,
yes, and just to complete that circle, at our first meeting, part of my presentation was my best attempt at picking out recommendations from that report and also the earlier report from 2013. So I did make an effort to do that.
My sense is they were captured, but I asked Jeff to take another look just to make sure. It sounds like they are. So I guess the answer to your question for me, Madam Chair, is no, nothing new to add. I have comments on some of the things that have been suggested, but nothing new to add.
Okay, and because the list is not updated, there was actually another suggestion made at the end of the meeting by Chuck Storrow. And can you repeat that recommendation that you made?
Yes, Madam Chair. Chuck Storrow here. What I recommended was that the work group look at some provisions in Section 248A,
Right.
dealing with the permitting of telecom towers relative to the ability of a town to make the applicant make a presentation at a public meeting to the Select Board and Planning Commission. And then there was a provision in there about the ability of a town to ask the Department of Public Service to retain an expert for, to look at the issues that the town has raised. I could send an email in with the specific subsections in 248A where those are. I don't have them off the top of my head, but they're in that statute.
I think, personally, I think that would be very helpful.
Yes.
I'll do that.
Can you do that? I was actually going to ask you to do that before this meeting, and it's my glitch.
Thought of it. All right.
And so that would be great if we could get that. We also had a recommendation that came from some of the folks in PEG Access Television, Lauren Glenn Davidian, identifying very specific language that had been sent in that I think would be helpful to look at. Do we get that? Andrea, get that out. That.
I'm not sure.
I printed a note. I have it here.
Yeah.
You mean Lauren's comments?
Lauren Glenn
Mhm.
Davidian. I think that was in my email.
Yeah.
I just need to find it. I have it.
We have it.
I looked at her comments, but I didn't see any of PEG.
No, that's just that's just the,
Oh,
That's who
okay.
she is.
yeah,
Oh,
that's the acronym.
Got it.
All right. Are there any others that we want to capture. I have one. Representative Klein, no, okay. I actually had a recommendation that it's not something we can do, but in terms of making recommendations to the legislature to look at things, I thought it would be important for us to recommend that the legislature look for or identify a funding source through VILBAC or other for interveners in a so to have the public advocate office. I didn't specify where that office is, but some type of support for identified participants. So that was my recommendation, and that might go along with what Chuck, you're actually recommending. So it might be a combination of recommendations that we can make in that.
So I found her email, and essentially, one main area of concern for her was that with VIT gone, we need to come up with an alternative way to make it easy for constituencies to reach the board from all parts of the state. And that was, in fact, one of the recommendations on the list that I brought 2 weeks ago. And she goes into a little bit more detail and gives us a link. That was also mentioned by someone speaking on her behalf at the public hearing that we had.
Yep.
And the night.
Right.
And so we could recirculate her email, but it's.
I don't think we need to. Yeah, that.
And there were 2 other points that she made. It was. Sorry. It would be, she thinks it would be valuable for the board to clarify how important the quality of public participation and interpretation of that data is in their decision making. I think we addressed that in one of our recommendations, which has us endeavor to reflect more on public comments consciously, both at a later technical hearing, but also in our order. And then her third is, since she says the DPS is not adequately experienced in survey design or the publicity and management of focus groups, which feeds directly into the public process for the PSB, nor is there a DPS public advocate that focuses on telecom issues. And so that's just a concern without a proposed solution as far as I can see. So that was it.
That was the other one. Good, thanks. Okay. All right, we'll call that out. I think we should add those to the list. Okay. So. Judge Mello,
Yes.
any additional recommendations or areas that you think we should be adding in?
Sure. So number 1, I don't think we should include the recommendation about changing the name of the Public Service Board to the Public Utility Commission until much later. I don't think I agree it's confusing the public, and so it should be done, but it shouldn't be our first recommendation. So that's just a stylistic issue. More substantively, to my ear, the loudest complaints and the most consistent complaints we heard were inability by members of the public to participate in hearings, and when they did participate, the feeling that what they had to say didn't matter, nobody heard them. So I have some recommendations along those lines. I don't have a lot of details, it's just conceptual at this point. I'll have to, if the working group agrees that these should be included, I'll have to rely on the professionals at the department and board to flesh them out. But they go like this. Number one, it should be clear that members of the public have a right to attend all public service board hearings. Number two, in those cases of significant public interest, and I don't know how to define that, except that it's not every small petition, but the larger petitions, that the board should be required to hold at least one public hearing, if not more. And I know that this is something the board is wanting to do anyway. Number three, everyone who comes to the meeting should have an opportunity to speak. So if the meeting room is too small, then, or if the board hasn't set aside enough time, then it needs to come back or something. But there ought to be a public hearing, and members of the public should have, all the members of the public who come and want to speak should have that opportunity. Number 3 or 4, I've lost count of the number. But
You're on 4.
You're on 4.
Okay, thank you. Number 4, when the department receives comment from a member of the public about a matter, they should get a written response if it's a written comment. And they should know whether the department is going to support what they're proposing or not. So that if the department is not going to, they should at least know that.
Can you say that again? 'Cause I lost it. So
If a member of the public, if the department receives a written communication from a member of the public about a matter, that person should get a written response, which acknowledges the receipt of their comment and lets them know whether the department is going to advocate the position they're asking for or not, if the department knows. So if somebody writes in and says, I don't think there should be windmills on top of any mountain for XYZ reason, they ought to get a written response. They probably do already, I don't know, but they should get a written response saying, thank you for your comment. However, the department is taking a different position in that matter, and this is the reason. So the person at least knows that the department got their comment and is either agrees with it or disagrees with it. And lastly, which I guess is number 5, in matters of significant public interest, not every routine case, but in the matters of significant public interest, the Public Service Board, I think, should be required, I would respectfully submit that the board should be required to include in its decision, I skipped a step, but I'll come back to that one. The board should be required to include in its decision a discussion of the public comments it received and why the board does agree or does not agree that those positions are in the public interest.
Can
So,
I, before you
members
go,
of the public
go ahead.
I'm sorry?
I was just going to say, before you jump to the next one, what you're asking for is a responsiveness summary. So when a comment is made, you're asking the board to respond to that and to indicate if and how the comment was considered. Is that what you're suggesting?
Yes, yes. So if the person testifies to X, a member of the public says X is what you should do, and the board is not going to do that, it should explain, we got this comment, and this is why we do not believe it would be in the public interest in this case.
Are you talking
So
about
that-
the board or the
So
department?
that the public can know that the board considered their position and why they rejected it.
So Judge Mello, question. The last two that you've talked about, you've asked the department, so you're talking directly about the Department of Public Service, to give a written response and acknowledge that the comment has been received and whether or not the department will support that position, or give the department's position. That's what you're saying?
So the person knows whether
Yeah.
the department is going to agrees with them or not.
Okay, and then the next one, your number 5, is about the Public Service Board decision itself. So when a decision is rendered, then the board has an obligation in some way to respond to each of the public comments that were heard at the public hearing. Is that,
Yeah,
I'm trying to figure out where the public
necessarily-
comments are.
Not necessarily each one. If there were 10 comments
Yeah.
that said one thing and the board, they can just lump them together. But there should be a section of the decision that says, we received the following comments. These we agree with, and we've incorporated them into the decision. These we disagree with because they would not be in the public interest, and here's why.
Okay, I think
And that way nobody can say that the board didn't at least consider their position.
so. This would be a more formal responsiveness summary. I think it's on the list, so we'll
It is.
flag it as we go through the list.
Several of these things are already our practice. In cases of, contested cases of significant public interest, there are public hearings. Everyone does have the opportunity to speak. Sometimes those are limited by minutes given, depending on how many people are in the room, just like a legislative public hearing. But everyone does have the opportunity to speak.
Well, we've received comments from people saying that that didn't happen, so I just want to make sure it does happen.
Yeah, and you're right, in one case, that did happen, or rather not, and that was a recent case where the participation was limited. But in most, I'd say all other cases that I'm aware of, we've attempted to get large enough rooms to accommodate people and give them a microphone and a time if necessary.
Okay, so this
But
will,
if the working group agrees, this could be done either by a statute or by a public service board rule, I think. It doesn't have to be a
It's a
statute.
procedure, it doesn't even need to be a rule,
yeah, it's a
I don't think.
procedure.
Well, I assume right now, we're just trying to get everything on the table, we're not actually commenting on the.
Just trying to
Yeah,
understand
gotcha, okay.
what the recommendations are, then we'll go through and hash
Great,
them out.
thank you.
Number 6. You had a number 6. Bob.
Well, I was thinking of including a suggestion that when the department takes its position with the public service board, that it let the board know in some formal way the comments it received that are inconsistent with its position, so that the board would have them. But I don't know if that's a good idea or not. That was the one that I missed before.
Okay, that's worth having a conversation about, I mean, assuming that those comments aren't also submitted to the board in some way. So,
Right.
yeah, you're right. Okay, so that's helpful, so that communication from department to board. Okay. Yes, ma'am.
This is Margaret, and I think one thing we also heard as a theme was the lesser formality and the perceived, I was searching for the right adjective, perhaps, accessibility of the Act 250 process. So we went back and looked at the list that I brought 2 weeks ago, and we highlighted, Ann Bishop did this for us, the steps on this list that mirror, as it were, the spirit of Act 250, sitting around the table value, and that reflect the more sort of the quasi-judicial. So, Judge Mello, what we have here is a yellow highlighting on the list that I brought 2 weeks ago, where we thought that spirit was reflected in the suggestion. And is it so Ann Bishop is going to email you that, and I thought it was a really good exercise for us. If you look at all the yellow, it's a significant coloring of the steps that they suggested, and reflect, recognition of that desire on the part of the public that we've already tried to start instituting. And some of these go further than that. For example, there's been a move through EPSB where in the future people will have access to transcripts in their entirety and at literally the touch of a finger, and that's not possible in any other part of state government. Normally you have to pay for a transcript. So there'll be things that go beyond. So I just thought that was an illustrative exercise that it just should help the world understand the sort of direction that we're going.
Very good, very helpful.
So Madam Chair, when you're, it sounds like you might still be trying to accumulate new ideas, if there are any, but I'm
Trying
prepared.
to corral as
Corral
many
the
as we
group.
can.
I know
right
we're
now,
a
yeah.
tough group to corral. On behalf of the department, I'm prepared to respond to many of these, not all of them, but I'm prepared to respond to many of these, particularly from Margaret's list from a couple weeks ago, when you want to comment on the pros and cons associated with some of them.
So I think our goal is to go through the recommendations and as a group, and then make a decision for inclusion or combination or throwing out. I don't feel that we have any that absolutely have to be thrown out, but maybe modified a little. But you may have a different thought I've had that's legitimate. So I started another little process, because I'm a category type person, and so I went through and tried to think, and this is not inclusive by any means, but to make a list of by category, and if this might help us get to the recommendations that we'd like to make. So for example, the biggest paragraph there on Act 250, that we would take out, we would call out those things that we think reflect the Act 250 process. We could do it.
That matches what I.
So it matches what you did, that's what I said, wow, that's good.
Thank you.
Because this is how it was brought to us. We can, and then, so then suggest some justification for the recommendations that we're making. Then recommendations to improve documents for citizens, so something there. Recommendations for, that require legislative action, so not all of these will, but some do. And then the one on supporting citizen participants that I brought up, the funding source and the interveners, sort of the public advocate office, wherever and however that is, and I think that might draw some conversation.
I'm gonna need to comment on that.
Yeah,
Yes.
and I put it in there deliberately to do that. And then diverse geographic regions, and that would allow for the board to travel around the state, but also the addition of any kind of telecommunications access. So so there are different ways of organizing this, but these were some of the things that I pulled out.
Senator,
Yes.
there's, in the tax code, there's a provision for the creation of a position within the tax department of something called a taxpayer advocate. It's in 32 VSA section 3205. And I don't know whether that's something that would be worth considering here. You and Representative Klein might have a better sense of whether this is even worth doing in the tax department. I don't know if the position is a joke or a really serious, doing serious good work. But I noticed that position in the tax code and wonder whether that's something that we might want to consider making a recommendation
Hey,
for.
Judge, this is Chris Recchia. We did actually consider that model in the context of the Energy Generation Siting Commission work. That is someone who helps with process. They do not represent the taxpayer in the context of like, this is what I want to try and get out of this. How do I figure out how to do that? They don't, right? So it's not a substantive, it's a procedural, which brings us back to the ombudsman issue, which I think is that purpose. But we have looked at that model.
Okay. The same concept then, just different name.
Yes, although just to be clear, the name unfortunately implies that you're actually going to advocate on behalf of the taxpayer, and that is not what happens.
Sure. No, I understand that.
Yeah, I know you don't. Okay.
One of the things that the taxpayer advocate is supposed to do is identify subject areas where taxpayers have difficulty interacting with the Department of Taxes, identify classes of taxpayers who have common problems relating to the Department of Taxes, propose solutions, including administrative changes to those procedures, recommend legislative action as may be appropriate. So a lot of the things we're talking about
Sounds
ourselves.
like us. Right?
Sounds like what we're doing.
Yeah.
Yeah, that sounds like the charge that we were given.
Yeah.
Yeah.
But this would be creating a position at the board or department or something where the person would be doing this for people participating in the public service board process. If this taxpayer advocate position has proved to be valuable and useful in the tax department, perhaps it would be valuable and useful here. That's my only suggestion.
So Commissioner Recchia, when
Yes.
you evaluated this position, what were the,
I think we fed it into, once we realized that they were not actually advocating on behalf of the taxpayer, like, I feel like I have been
Yeah.
wronged by this particular tax thing. Can you help me get this resolved? Once we realized it wasn't an advocacy position like that, in terms of advocating that consumers' concerns, it was about advocating for the process and making sure that they can facilitate, entry into the discussion. That really fed into the concept that went into the ombudsman person, like somebody who can answer the questions, not to represent you or your interests, but to tell you how to navigate the process. That was what that really came down to.
so when you, can I ask another question, a follow-up? Because I know this is going to be an ongoing concern, regardless of whether it's here or in the State House. When you were having the conversation, how did you look at the large expense that falls on individuals when they are interveners?
So this is, right, well, so
I mean,
when
it's
we
a-
get to intervener funding
major
is.
case,
Right,
contested case.
right, and this is really hard. We have talked about this multiple times and evaluated it multiple times. And the question is, who gets the funding? If you generally, you start with a group, let's say, okay, I'm gonna give you a hypothetical, but it's not too far from reality. You start with a group of people that say, we have this interest, not that interest, can you help us? If you chose to fund those people, and they got 75% down the road and were agreeing mostly with what's going on, but there's 25% of the people say, my interests are somewhat different now, or I'm not agreeing with where the group is going. Give me intervener funding to do this. And it might go down to the individual. In other words, how do you decide who to fund and who not to fund?
So that's a question that falls to the board, and how intervener status is determined. And so,
Okay, then let me give you an example.
Go ahead.
Now I wanna go to an example of where we actually specifically did this in a case, and because it's still going on, I won't mention the name, but I will say that we did for eminent domain processes, which are clearly individual property owners' rights
Mhm.
and their individual ability to do this. We provided funding for their legal support. We provided documents that would give generic support for what they should be watching out for and how they could represent themselves. And in cases where the expenses were more than the basic funding that was given without question, just $5,000 here, it was, if you can identify further expenses and have invoices and things, charges related to either legal fees or things like that, we'll get those paid. And we did. It made,
that might make the news.
it did make the news? I don't know. I didn't hear about it. And it didn't make. It
Should have
didn't-
made the news.
Yes, it should have, and it didn't make any difference in my mind. People took the money, they negotiated what they wanted to negotiate, they agreed or didn't agree when they wanted to. This was intended to be, like, you're only taking the money if you're in good faith negotiations in the context of trying to resolve your issues. Some people took the money and then just continued to fight the project indefinitely and not settle. And I don't know how is that in the public interest when all of this is ratepayer based, when that charge goes back to ratepayers, which was part of the condition of this, to understand how this would work. Look, I appreciate people's desire to participate. I want to provide for that. But the reality of this job has been for me to recognize that people are not always faithful to how they represent themselves. And I used to be probably the most optimistic, accommodating person in terms of like believing people's motivations. And frankly, I've been changed by this job as a result of this.
Okay. All right, so we'll come back to that one. That's the last thing on my list there, you'll see that. So, and I think it's gonna
It
be
is sad,
part.
because I feel, I've spent my life in public service, not public service department, but public service, believe in it, believe in people's interests and motivations, and I'm extremely disappointed in what I have seen, at least the last couple of years. Very distressing for me.
Hopefully, some of the recommendations we make, once it's implemented, will restore your faith in.
I hope so.
Right, we hope so. All right,
Commissioner Recchia, the ombudsman issue, is that the one that's on the list that we received under the category Create a Public Assistance Officer?
Yes, it is, Judge. That's exactly right.
Okay.
Now, I have
Right.
a disagreement with Board Member Cheney about that being in the department versus the board, but I'm happy to discuss why I believe that to be the case. But that is the one, yes.
Wherever it ends up being in, perhaps that's the first recommendation we should be making, rather than the name change.
I agree.
The reason, I agree with reordering the name change, that does, for various reasons. That is within the category, at least in the list, that the way I organized it, of things that would require statutory changes. So, and I think that in general, we didn't give any thought to any kind of implied priority to these recommendations. And I think that is something that we should give a little look at, in addition to grouping them a little bit more logically within their categories. But, so that's, if we keep to the statutory change block, then that could go at the bottom of that block, but not at the end of the list, is my suggestion. And I also think.
Ms. Cheney, can I ask you what the last item in that block means? Assign responsibility and resources for enforcement to the department. What does that have to do with improving public access?
Maybe I could.
Well, ease
Go
of,
ahead,
remember,
Ms.
it's not improving access, it's ease of public, participation, and part of participation in a case goes from the beginning when one first learns of it to concerns regarding whether conditions of a permit have been violated. So enforcement goes to the public interest in enforcing the conditions of a CPG.
Judge, just to follow on that, and this is one that I actually agree with, I think that what happens, and it is in kind of citizens feeling like they've been heard when they see a project go into effect and then the conditions that have been imposed aren't being met, or they thought they were going to be different and they don't really have any recourse. And you probably don't know this, but my background is in agency natural resources, where, you know, if someone violates a condition of a permit, that can be enforced by the department itself. And if someone disagrees with that, they have, you know, they certainly have the right to appeal that to the environmental court or the Supreme Court, as the case may be. In the case of the structure of the department and the board right now, the department can identify, when it's brought to their attention, things that aren't in compliance with the CPG or an order by the board. But we have no ability to enforce that directly and have it be appealed to the board. What we have to do is recommend the board take enforcement action relative to that. And with the dockets and numbers of things that they have to deal with, that is a two-step process that is more cumbersome and less efficient. And what I think Margaret's referring to with respect to the DigSafe program is, by federal law and responsibility for a program, we do have direct enforcement authority over DigSafe. And if someone disagrees with that, they can appeal that in the appropriate forum. So that's the difference there, and I do agree that that would be helpful to do. Does that make sense to you, Judge?
Well, thank you very much both for the explanation. I don't remember anybody complaining about this in terms of public access. It may be an excellent policy to adopt. It just isn't obvious to me that it has much to do with public access.
Okay, so the way I would link those two is to say there have been cases where we've been called after the fact by citizens who participated in the project, thought they got what they wanted, and then saw the implementation of it and said, this didn't meet my goals, you know, right or wrong, and feel like that then implies that the board wasn't listening to them, or that the decision weren't implementing what they thought was going to happen. And so it is an actual manifestation of that concept when the project is actually implemented and it doesn't appear as people thought it was going to. That's how it's connected to the kind of access and belief that people are listening to them. And I understand where you're headed, but that's the
once the
connection.
decision is rendered, then people have expectations about what's going to happen.
Correct.
And if you don't have enforcement of what's been decided, then citizens might be caught in a catch-22, that something is not happening that they had expected would happen.
Yeah, and I'll give you an example, and this is totally generic. I don't know if it's ever happened ever, but for example, one could imagine that one of the conditions in a CPG, which in turn might have resulted from some sort of stipulation between a resident or a town and the developer, might result in a condition in the certificate of public good in regard to how far back from a property line or from a road a project would be set. And then the project is built and it's discovered that in fact that setback requirement wasn't honored. That would be a violation of the condition in the CPG, which in turn had resulted from citizen participation. So you have to have an ability to close the circle and enforce these agreed upon conditions, and in fact is a legally required condition.
I do think it would actually free up some, well, first of all, I think it would make the CPGs more effective, but also free up some of the board time if the department could take initial enforcement actions, understanding that they could be appealed to the board if there's a disagreement, and that's perfectly appropriate.
Does the Public Service Board agree with this recommendation, or if we included it in our recommendation, would we be doing something the board would strongly oppose?
All of these recommendations, Judge, were offered by the Public Service Board.
Oh, okay.
All 5
Great.
pages of these recommendations came from us.
Thank you. So, Senator, please forgive me, but I've got a jury trial that's resuming at 2 o'clock.
How could that possibly be more important?
Well,
That was a rhetorical, facetious question.
I'm not saying it is more important.
Oh, okay, that's good.
Give them
Thank-
hell, Judge.
Thank you.
Thank you.
Ed, listen, sending your thoughts, your 1 through 6 by email would be very helpful, and we can
I'll be
help.
happy to.
Yeah, that'd be great. And what we'll do, I think, for a little bit more time, is to go through recommendation categories, as Andrea sent to you earlier today, and try to sort out, do we want these categories at all? And how might we organize the recommendations so it's comprehensible once it gets to the people who have asked us to do this. So, there, if
Perfect.
you-
I'll be happy to do that later today.
Terrific, thank
Thanks,
you.
Judge.
Thank you very much.
Thank you very much.
All right.
If-
Bye.
Bye.
If I may take a first stab at these categories?
Sure.
So,
Go right ahead, stab them away.
so, oh, perhaps that was the wrong noun. So, I think that, I agree with having, things categorized, and some of these I noticed though are, go to the intent, or, for example, recommendations to improve documents for citizens, and others go to process, like recommendations that require legislative action. So, and then going up to one of the first ones, let's see, where is it? The Act 250 suggestion, we've come at through the highlighting. So I think that we first have to decide whether we want to do more process-oriented categories or goal-oriented categories.
And so my reaction to that is I do see some overlap or places where one recommendation might appear in 2 places. It's advancing citizen participation, and it requires legislative action. So
Yeah,
I
or
kind of
you could
agree with that.
asterisk. You could asterisk like the ones that need.
Legislative action.
Sure,
yeah.
okay.
So
Yeah.
I think there's different ways, but I think the categories are good.
Mhm.
But I think because of the level of detail that Margaret and the board put into their 5 pages, I feel like maybe we should work through that and then put them into the various buckets that Senator
That's
Lyons
what
has
that's what I was actually
That's
gonna
what you were
recommend.
try and do.
But you're okay with thinking about some categories?
Oh, yeah, I
But
think
these are
it
not,
makes sense.
these are not set in stone.
Yep.
And as you said, they might be looked or have slightly different.
And one other observation is that I think that when we do finalize these, some would benefit from some context. You know, for example, when we have this section on EPSB, and we were thinking, I've got it right here, in some ways that besides just saying, wow, we're going to do EPSB, how many people really understand what that is, or why that matters so much? And that presents an opportunity for something along the lines of, for example, let me find it, explaining that I started to go into it a little bit, in terms of what a big difference it will be to be able to find online every word of every transcript of every evidentiary hearing, which you can't even do it for court cases. You do it wherever you are on your laptop in the future. But then in terms of the
So.
So it levels the field for them, you know, vis-a-vis, what have typically been lawyers. It gives them their own Westlaw system.
Yeah.
So, I mean, I think that it's an opportunity, to avoid glossing over what sounds like simply an online, sort of technology change. It's much more than that. So I hope, I propose and we offer to provide some, you know, sort of preamble each of these that explain it.
Good, I was gonna suggest that, so that's
Mhm.
great. And that's why the few sentences on Act 250. And
Right,
just,
right.
you know,
What it is that we see as, you know, that people are meaning when they talk about that.
Right, right.
You know, that sort of being at the table kind of, idea.
the question is, how much clarification do we need?
I don't think in most cases you need any. I just think perhaps
There's
there's a
some that-
preamble to each category.
A couple of sentences
Yes.
that
One
or
describe
two
why.
sentences,
Yeah, I
exactly.
think that's right. I think you could do that in 1 or 2 sentences to explain why it's.
So, Madam Chair,
Sure.
I have been sitting in most of these meetings, all of these meetings, and listening to everything that has been put before us, and I keep going back to what the legislative charge is, and to me, it's a narrow path of, you know,
Ease of
how can
citizen
we
participation.
promote ideas of increased ease of citizen participation? It is just, I think, dawned upon me, unless I'm totally brain dead, that maybe we have not defined participation.
Do we need to? I mean,
Well, you know,
did we
we
receive
heard a lot of stuff from public input, and we could interpret it in a lot of ways. I mean, some of the stuff, I think, Chris said, well, what you're really saying is that, no, one gentleman actually sat there and said, well, we really want to know how we can influence decisions.
Mhm.
So is that the definition of participation? And
I would rephrase that. I might say how or how not the information we provided was used in decision-making. Then that goes to Judge Mello's comment about a responsiveness summary. I mean, so there are ways to get at that particular concern that people bring.
I think, and then
We
that's
are-
one, but there are others.
Yeah, so keep going.
well, I'm just, you know, I'm just,
Can I jump
Yeah.
on what, and I don't let me put words in your mouth, but
Don't
this is
worry.
part of what, but this is part of what I was trying to say before a little bit, in that if the outcome is not what people feel is appropriate, they feel they're not heard, they feel they weren't listened to, and they feel the board threw them off. And it's easy to say that, even when that's not the case. And I want to defend the board in this instance. I think they do a really good job of listening to issues and identifying it. But ultimately, unless you change the model here, that is, this is factually based, testimony under oath, cross-examination, discovery, defense by people who are experts or understand what they are testifying to. Once you change that, you're not going to solve this whole problem. And I hope people respect, and I do think, okay, as pessimistic as I was a few minutes ago, I will say, I don't think most people expect us to change that model. I think they just want a fair shot at understanding how to participate in that model when they can, under the terms of that model requires, which is basically legal structure. And they want to know that if they do that, that there's an understanding that that was considered by the board and responded to in some fashion. And I think that might be the sweet spot of what we're trying to deal with here.
So, I every time this issue comes up, I think about Paul Gillis sitting there and the question we raised to him. I asked him if he felt that the quasi-judicial process should be changed, and the answer was no. And so, and that's not our charge.
Right.
But our charge is to do, as you said, to ensure that citizens have access to the process.
So we might.
Some people will never be happy with the ease that they receive. They want it to be easier and easier, but, so.
We might be doing a positive service to the I think the two legislative committees that we're to report to, is that when we complete the tasks that has been committed to us to do, which is really a narrow scope, and we make those recommendations specifically to citizen participation of the current public service board process, I mean, we might want to think about, and I would propose that we would, submit everything that we heard, you know, here,
And an
committees,
appendix.
here's all the stuff we heard that fell outside of what we felt was the scope, but you might find it valuable if your committees or individual legislators want to pick through it or get in touch with the folks that put it forth, and maybe you want to, present legislation on your own. But that's not our charge. But I don't think that we should throw away what has been brought to us.
So do you mean what's been submitted to us in writing? Because we
Yes.
don't have transcripts of our.
Yes, I mean what has been brought to us.
We could send them the tapes too,
In
right?
writing, and we can send them the tapes if they want. Here it is. Here's what we dealt with. Here's the whole body of the work. Our charge was very narrow. You may be interested in hearing more, so there it
So
is.
is that what is normally done with the legislative committee?
What's that?
A working group, I mean?
I didn't.
Is that what is normally done with a legislative working group?
Oh, you're asking,
I
you're
don't
both
think there
looking at
is
me.
any, this is
scary.
not a legislative working group, this is,
Well,
it's a,
what is it then?
as Aaron Adler informed us, because it has members other than legislators. it's
Well,
sub-
most
it's-
working groups that I've been privy to and indeed been members of as a member of the legislature included, they included statutorily required appointments from various categories of Vermont citizens, such as, in my experience, like the appraisal community or the department or A&R, weren't just legislators, but they were legislative working groups by virtue of being required by the legislature.
So, I guess the question that Tony is raising is a good one. Do we send in our recommendations as charged in Act 174? Or do we send in our recommendations and then an appendix with all of the comments that we heard without any further comment? So that there will be things included in there that don't meet our charge.
But then nobody can accuse the committee
I'm fine
of
with that.
not.
I think we need to do that, because I think that, somebody's gotta be the keeper of this
Right.
these
Yeah.
records, right?
That's right.
And, so we should do our report based on the charge and say, here's the stuff
Right.
that came in, that we were basing this on. and
That you may
everybody
find
will have
interesting
access.
and useful.
Yep.
Okay.
Madam Chair, I'm gonna have to leave by ideally 2:30, but definitely by 2:45.
All right, so let's try and wrap. Let's see
Okay,
what we
so,
can do
so, first of all, can I comment on the list that was provided by the board,
Sure.
basically? And just thank them for spending the time to do that, because I think that was extremely helpful. And also pretty, clear that they were being self-reflective in that, and I appreciate that. I can provide you with comments on all of these things, but I wanted to focus on the main ones that I thought were really important. And I want to start with a positive one. So this idea, so I'm on page 2, the first circle bullet at the top of the page, that before a board's public hearing, we hold an informational session, the department can host that.
Where are
We can do
you?
that. I'm on page 2 of the,
Oh, the open circle, the first one?
yep, first open circle.
Okay.
Because this is one of the, I think, best recommendations that I've heard, and to try and pull these pieces together, and I wanted to really emphasize it. The department would be delighted to do that, to have the applicant make a brief presentation, have the department make a description and a presentation about what its concerns are or what it sees. Let the public ask questions, and then go into the formal public service board proceeding and distinguish those two. I mean, they do need to be advertised together. In other words, when the public service board says, we're holding a hearing on such and such, and by the way, there will be an informational session an hour before to ask questions, to get some basic understanding, clarity. It will not be part of the record, but I don't know, can it be part of the record?
Well, it will inform their comments, and I agree.
It will,
I think
definitely.
this is a huge one, because right now people come and they don't know enough about the
Right,
project
right.
to comment except sort of generically, and so Chris is right, that's a big one.
It is a big one, and I think I mean, to me, this is like the huge solution to connecting a bunch of these problems. So that's one I would like to say. We've always supported the idea of creating a public assistance officer, but we do believe it should be at the board. The department has consumer affairs people. We have people that answer phones to say, what do you think about this? What's going on? But here's the problem, and here's why I think it's important that it be at the board. So first of all, we can't see into the board process any more than any other entity out there, any other intervener. We do not know what the board is thinking in terms of scheduling things, or where this is in the process. And I'm talking only procedural and process issues, that somebody should be able to say, yep, we got that request. We're thinking of doing a schedule next week. You'll be invited to that, or we can put you on a list to be invited to that. Or, yeah, it's in the hearing officer's hands, and they're planning on doing a proposed decision no later than a month from now. But we in the department it's opaque to us too. We cannot answer those questions that people have about what the board is doing with a particular a proceeding, a particular docket, where it is on the schedule. And those are things that we feel like the board should be able to answer and do so for itself. We also are in the position where if we, and we ultimately do, take a position on a docket, right? And it might be in the beginning, it might be in the middle, and it might be in the end. But ultimately, our responsibility is to take a position on a docket and tell people what we think is in the public interest. To the extent that there are parties that disagree with that, they will no longer want to call us and say, hey, tell me how can I influence this? How can I participate effectively? What can I do? We'll tell them, and we do, but they don't believe us. So this is why, those two reasons are the reasons it seems to be located at the board. We'll still do our consumer affairs work and try and help people, and maybe there's a different way, maybe there are other issues here that are making the board think that this should be in the department. But those are the reasons that the department thinks it should be in the board, is really process related.
Well, should I respond to that now or wait for Chris to go through this? Because
Let's just, I mean, this is
Yeah,
one that I really wanted to discuss today, so let's
Why don't
discuss.
you, and then I
Yeah,
have a
absolutely,
comment.
please.
And I think Chris makes some very good points. And I'd say to summarize why we don't think it should be at the board is that we are essentially the deciders, we are the judges, we have, we are not in a position in any way of being an advocate for any parties. So that having been said, so much of it depends in, both our positions on what exactly such a person would do.
Right.
And also the challenge of having whatever that charge is not bleeding over into becoming taking one side or another. And as you said earlier today, there are often multiple sides, and sometimes someone's position can morph into something that it wasn't before, and they'll split them off and
Exactly.
they thought what they were to begin with. So, that having been said, I think that there is an argument for having this not be an active recommendation, but perhaps being one that is a possibility after a report on the progress that we've made as a result of these suggestions. Remember, one of the suggestions I made was that in a year we have we do a report on the effect of these changes, and some of the deficit that is highlighted by the desire to have a public assistance officer may in fact be remedied by, for example, EPSB. Some of the things that you were mentioning,
That's
Chris,
correct.
like where is this case now? When's the pre-hearing conference? How do I participate as a potential pro se intervener? A lot of that will be instantly accessible through EPSB and easily searchable. And so it's possible that the PAO desire, need, will be fulfilled by that in particular, but perhaps other changes that are on this list. So that's one reason, I thought that one of the things we should do is not just make these recommendations, and in fact we're already doing so with many of them.
Right, you are.
But really do an assessment in a year or whatever time period you think is appropriate.
So, right, perfect. I mean, I think the EPSB thing is going to help us. It's going to help you. It's going to make things electronically available and accessible to everybody. And to the extent that it fulfills the purpose that you just described, is exactly why I think a public assistance officer can provide that information. In other words, not substantive, not advice, but procedurally, this is what's happening and where you can find this stuff. And maybe you rely more on the PSB, EPSB, thing. Maybe you refer people to the website and say, here, let me show you how you can find
Well,
this.
yeah, I mean, my point is with that added tool, which is far more than one person. I mean, it would be like having a whole new staff.
Yes, it is. Yeah,
it's a
great.
virtual staff. It's
Yep,
EPSB world, which
Yep.
I think will be equivalent to more than one full-time position, far more. And therefore, it's possible that you don't need to create a new position. You could
Maybe not. I mean, maybe not, but you do need somebody to help people. I mean, if you agree that the concept, if you agree with the substance of that this person should be able to answer those type of questions, in my mind, it needs to be at the board in some fashion. Now, it might be electronic, and it might be mostly electronic, and it might be just the clerk saying, hey, yeah, let me show you, or you go to the website, you'll see this X, Y, and Z, and press here, and you'll get the
Can I ask
answer.
a question here? Are we debating where something should be housed?
I think
we
we are.
We are in agreement.
I'm
Of the
saying, I
basis.
don't think this should be a recommendation in this list of recommendations, because I think that the need that is perceived that it will provide, or the problem that it's perceived that it will solve, will be achieved in other ways
By the
on
electronic
this
stuff.
list.
Okay, so in that respect, I would say I disagree
Okay, so
respectfully.
if we can't get agreement on that,
Yeah.
and somehow we end up with recommending that a position of this type should exist, and we're arguing or debating whether it should be the PSD or the PSB, well, if I don't know how it would be funded, but I'm sure it would be funded with ratepayer funds at a certain point. But PSB, well, if I don't know how it would be funded, but I'm sure it would be funded with ratepayer funds at a certain point. But if that's the only issue, then house it with the legislature, in ledge council, and have an additional body, you know, higher that is housed at ledge council and is responsible to the people, the legislature, and it is funded by ratepayer payback. That's simple. Then there is no issue of bias.
So I have to tell you how much,
You can't
because
do
you know
that.
I love you,
That-
but I
that's
hate that
con-
idea.
isn't
I
that
absolutely
like
hate
a-
that idea.
What
'cause-
is that, a conflict between the?
Well,
the-
No,
it's
that's
a
not.
matter of
It's
knowledge.
neutral. It's
No, it's, but you
no,
don't
no.
want
You have to
neutral.
have a knowledgeable person. It
But you
doesn't
need
matter
to-
where they're
But
housed.
here's my point, is
I
if
just-
I call
I
you.
still don't see why
legislative body.
anyone, why you think this position is necessary
Okay.
without first giving a chance for some of these changes to take
So,
hold.
so let me
Can
comment on that.
Can I make a suggestion?
Of course you can.
I mean, I see it
Fun
by,
we've had.
I know you have to go, but I just want to
No,
say,
not for-
what we're trying to do here,
Yeah.
I think, in this conversation, is to clarify,
The needs.
no?
No, it was started
No,
out
we're
as where it
clarifying
should be.
whether or not the advocacy position should be in the board,
Right.
at the board,
Right.
or the department.
Right.
And I know we did have something of that same conversation in the legislature.
Yes, we did.
And so what we might suggest, so we can respect the good work that's going on in the board,
Absolutely.
is to say that that clarification should take place based on information received from the board. So the
I mean, after
the
a year.
assessment, after 1 year.
Yeah.
Okay, so do that,
Okay.
and then,
Okay.
and then
Okay.
can I
That's
just
my
add,
recommendation.
and I'll add one piece of that.
I am okay with that.
Okay.
Isn't there a little pilot project going on right now in the AG's office? Is that
Well, there's
happening?
something going on in the AG's
Yeah,
office.
I'm not
They're
sure.
evaluating our public advocacy work for this past year. They're gonna do a report shortly.
Right,
And-
so,
But,
this'll be interesting.
yeah, it will be interesting. But that's substantive. That's like, are we doing our jobs?
Yeah.
And
Well, that
so
would
I
be-
want to agree with Margaret because I want to say that.
But I just, so let me finish, so after I said that, then that
He
means
was
that
agreeing with me.
there's another report
I
coming
was
through.
allowed to finish,
There was a lot
sorry.
of agreement going on, I think, right here, but, my
Except for
cons-
the ledge council thing.
Yeah, well, that. Separation of powers issue, so anyway, all right, you finish and then I'll
Okay,
hold my.
so
thoughts.
what I want to.
Information officer.
I want to agree, right, it really is informational, and here's the, I want to agree with Margaret in the sense that the PSB thing, the docket thing will probably solve a lot of problems, but it's like, you know, TurboTax, yeah, that solves a lot of problems, but sometimes I need to call somebody and say, hey, could you tell me what this means, or what's going on here, or how to interpret this? And to me, whenever that call is made, it needs to be to the board, because we do not have, the department doesn't have, and with all due respect, the ledge council would have even less, understanding of, okay, what are the facts here? What's the issue? So, again, procedurally, you are under no, this is not an ex parte issue. This is not a, like, you know, this is like calling a court and saying, could you tell me, you know, how likely it is that this thing is going to be scheduled 3 weeks from now, or it's going to be 3 months from now? Or could you tell me who the person is I need to speak with about filing these papers, and who can help me? But that to me is all the
Well,
board, not the department.
May I really like your idea of having it be more fully informed post-assessment of how we're doing, but I need to turn to Ann Bishop and ask her if what I just said about the EPSB solving some of these issues, would you agree? Or, I mean, I just said that because that's what I believe, but
Well, me
Ann
too,
is our.
because we're spending a lot of money on it, I sure
Well,
hope it does.
But Ann is really the spearhead person on EPSB, so how would you agree with what I said or not?
Yes, it's going to solve a lot of the issues. I think some of what's happening here is that you guys are talking a little bit about slightly different questions. The questions that first came up of, what's the status of this case? When is the hearing scheduled? Did you get my filing? What are the projects in my town? How can I file a public comment? All that kind of stuff is going to be in EPSB. The question that Commissioner Recchia, that you were starting to ask about, is it likely that a hearing will be in 3 weeks or in 3 months, is not something EPSB is going to answer. But I think what has given some people at the board pause is that those kind of questions very quickly bleed.
They do.
And so it's one thing when it's a straight factual matter
Yeah, I know.
where we kind of started this discussion. Did you get my filing? When is the hearing? What is the schedule? Can you give me a copy of the service list? Those kind of questions are easy to handle. I'm putting easy in quotes, which is they're straightforward. The information is going to be in EPSB. It will be readily accessible to members of the public that way. But it's that I think a lot of the concern is that you get to the second generation question. And
Yeah.
when you get to that second generation question, it becomes difficult for board personnel to be answering that many times because it bleeds quickly into how do I fill out this form? Instead of it just being what is the form I need to submit,
Yeah.
it's how do I fill out the form to persuade the board?
Should I use this word or that word? Okay, so,
And
you know what, this is brilliant. This is, I think this is exactly, I mean, I'm gonna state the obvious. This is the problem, right? There is no prohibition against the board providing process and procedural information to people. But people have multiple questions, and it is easy, you're right, it's easy to bleed over into this. So here's the problem. You guys are fully positioned to answer the first part of this, which is what's the schedule, what's happening, what's going on, and what do you need to do to fill out the form to get into this? Fine. We are in the position of helping people a little further in terms of like, well, if you really want to participate, this is what the most effective way of doing so is. But we can't answer the first part. So somehow we need to be able to provide both these pieces. We don't know. We just don't know what the hearing officers are thinking, what their schedules are, what their workloads are, what things are likely to happen when. I mean, forgive me, there are things we're waiting on since I've been commissioner that, they haven't been a highest priority, and I understand you guys are overworked, and so we don't call up and say, where the heck is this thing? But it's out there, and if somebody calls us and says, when is that going to be issued? We would be like, I don't know.
I think maybe
Those are the pieces.
One of the benefits of what Board Member Cheney was suggesting, I think, is that because EPSB is still hypothetical for the entire, for the people who do business with us, it's hard to say. I mean, our expectation is that based on the desire we have heard from people in terms of how much people want this new system, that they are really going to fully utilize the system and take advantage of its capabilities to access that kind of information on their own, online, without needing to call us. There will always be a small number of people who do not have internet access, who will need to call us, and we are expecting that just like somebody now calls us to say, can we please get a service list for this case, or something like that, because it's not on our website now, that there would be a certain amount of those kind of calls that would continue. But I think what Board Member Cheney's suggestion of waiting a year to see what's happened with the report would help identify the nature of the need going forward. And I think Commissioner Recchia, then, the way you characterized it as in the first piece of the first kind of questions, the board has the ability to answer. The second kind of questions, the department has the ability to provide, to go further with.
Correct.
And I think that maybe it would be useful at the end of the year, after we get the report, to see where are the questions coming from then at that point.
Mhm.
And that may help inform the further debate about this issue by the policymakers.
Okay, so we're gonna change the desk.
Change the date. Excuse me. Thanks, Ann. I'll be back in an hour or two.
So I do want to discuss the concept of intervenor funding at some point. And we can't do it without him.
You mean the concept that a public intervener or intervener should have some access to public funds?
In specific instances. So in certain cases, the highly contested, the ones that, as he said before, the eminent domain cases where people were directly affected. But, we can suggest that the legislature look at that as an option. But it has to be very narrowly defined.
Do you want me to go back and,
All right, we'll come back to this. And I think looking at the 248A stuff that Chuck, you were talking about, might give us some direction.
And that one point really tracks a lot with what Mr. Recchia is saying about this informational meeting prior to the public hearing.
Yes,
That's,
that's part of it.
they're aligned.
They align?
Yeah.
That's neat. Do you know what it is and where it is in 248A? Is it,
Just gonna send it to us.
we could.
Yeah, I'll take a look at it.
Okay.
Subsection.
Oh, I won't get antsy. So do it.
I think, I have notes from the last time.
Yeah, so do I,
Send it
and
along.
But
I
if you don't mind
well.
sending it, just to make sure that I'm the same.
That's during the 45-day comment period, when the applicant has to submit a draft of their petition to the town before, and give the town at least 45, or there has to be a 45-day period before they then can file with the board. That's when that meeting is supposed to take place under 248A.
Good. All right, we'll look at that. I brought up the topic of funding
Yeah.
for interveners or parties, so aware of.
Did you
the-
resolve it while I was out?
We did, we
Okay.
solved it, so
Excellent,
it's all
good.
done.
I'm good.
No. But, hearing your comments about folks who were under the possibility of eminent domain and some of your concerns about that, we aren't making recommendations to do it,
Right.
but it might be a consideration of something and how that happens
I know.
and the criteria for making a determination.
It's just
under
that I
what
do feel the
conditions.
obligation to point out some of the challenges, as if we are making a recommendation about, like, consider doing X, we should point out some of the pros and cons associated with that, that's all,
Mhm. Yes.
that's all I'm saying.
No, completely understood.
Especially as considering the rate payment.
Yeah, no,
Right.
absolutely. So there's one more that I really asterisk on your list, Margaret, that can I mention before I have to take off? I
Please.
apologize. So, there's on page 2, there's a solid bullet. This says hold more workshops to provide procedural information to pro se interveners. Jeff and I were talking about this, that it's a great concept, but here's the problem. You could hold these quarterly and no one would come because there's nothing on their radar screen that causes them concern to want to come. here's, as long as you're into the exciting e-world of electronics, why not do a YouTube video or a tutorial on this that you just put there on your website or made available, so that when people said, geez, this is a case I'm interested in, how do I do it, they would be able to find that. Because otherwise, you're gonna be taking a lot of time and money and presenting these things to nobody because they're not interested unless and until a case comes up.
That's interesting. Did you hear that, Ann? I know you were.
I'm sorry, I missed the first part of that.
It's okay.
I
So
apologize.
it's the idea that instead of holding workshops at periodic intervals
This
on
is
how
the page
to
2, the
provide
solid bullet.
procedural information to pro se
Mhm.
interveners, and of course you might give a party and nobody would come. Instead have basically a tutorial online that people can click on, like
When
it would
they're
be like a
interested in,
YouTube type
because,
of YouTube
because when they're gonna wanna see
tutorial.
that is when they're interested in a particular case where here's.
Yeah, there's a lot of how-to things on the web now, and that we
Yeah,
could mirror that kind of a.
So I think those are the 3 main ones. I mean, we have a lot of, minor comments on some of these, we agree with a lot of them, but I think it's a tremendous list. But those were the 3, I mean, the main things are, love the concept of the department holding an informational piece before a public hearing, as long as it's presented as a package that people come. Do believe that there's a need for an ombudsman of some sort, and we've talked a little bit about the distinguishing characteristics of that. And then this idea of providing general information in a way that's accessible to people when they need it, as opposed to taking your time. And Jeff, there are many others, but did you have any other big ones you wanted to flag?
On page 3, the provisions where there was suggestion about MOUs or settlements, I think needs more discussion. It's not, the recommendation there, does not seem like it would answer some of the criticisms that we've heard. And so I think that there's opportunity for discussion there, but it's, as stated, I'm not totally on board with it. One of the things that I think would be very helpful, and this is flipping over to the first page, the second bullet, in terms of when parties are supposed to file comments, you can't key it off the filing date because we don't know when that is. We don't know when the board receives stuff. And we're always getting calls saying, well, when do I have to comment? It's, well, so many days after the board got it. Well, when did the board get it? I don't know. The board is conducting completeness reviews, looking at applications and petitions to see if they're complete before they start the process. That is extremely helpful, and I think that dates need to be keyed from the board issuing a notice that, yes, this petition is complete, here's your comment date, or here's the date you have to respond to this motion or whatever it is, petition. But that is extremely helpful to people, neighbors, municipalities, whoever, and state agencies, frankly.
So you agree with that bullet?
Yes, I do, and I would just key
Although
it off a
you would
different
key
date.
it off the
Right.
notice.
Key it off
A
the
notice that the
application
petition is-
being complete.
Okay.
Exactly.
Rather than received.
Now, I have a question, that's gonna require a legislative change.
Could
Yeah,
we
a
have
statutory.
a follow-up, and Bishop would like to
Sure.
follow up on
No,
that?
good, this is very helpful discussion.
Yeah, I wanted to follow up briefly because we are doing that, particularly in some of the net metering context and stuff like that. And one of the things that I would want to take a look at is exactly whether the requirements for providing notice to adjoining landowners, et cetera, and this, I know there are statutory parties, municipalities, some of that language is in the statute, some of it is in board rules, and if this group is thinking that it would make sense, which I like that idea, of basing comment periods off of once it's been filed with the board and it's considered complete, there might be some logic to looking at sections of the statute that require the petitioner to file it with other people at the same time they file it with the board, and change that so that they file it with those other people after it's considered complete. That way they'd be able to provide the case number to those other people, as well as an exact due date for comments and responses.
And would that affect the intervention schedule at all, or would people still know that a project is occurring and be able to weigh in, as, like say, oh, I'm interested in participating as a party?
I don't think it would necessarily affect that per se.
I think I would be concerned if we waited, you know, beyond, you know, like to get all the filing complete in order to be able to have the intervention schedule, but that,
So it sounds like something, and you could give some more thought to.
We can give some more thought to,
And we
yes.
could refine that recommendation.
So I was just gonna say, you know, maybe June would have the
Yes.
statutory references that we could plug in.
Mhm. Yes, we would definitely.
So thanks, I mean, I'm afraid I do need to go, because I need to get, I'm sorry, I need to get going. But do you guys have the quorum you need to approve the minutes? 'Cause I'm fine with the minutes. but,
Yep.
I just wanna make sure you
We're
still
all set
have
with
that
that.
if I leave.
As long as we'll spend some time doing that, but I will say that I think that our next meeting, which is November 17th, that I think that we all need to look at the categories we'd like to have for our recommendations, and any additional recommendations, or things that we've talked about.
You're such a
'cause,
nice
we
chair,
can- we
'cause if
can
I
do
were
this-
chair, I'd have
we
said
can
no
do
more
this
recommendations.
forever.
You know, I
but-
think we could shorthand that though. I mean, I think, couldn't we take advantage of the 2 weeks intervening to assign someone, and I would be happy to offer to refine the organization of this? And-
Sounds good to me.
Yeah,
Because otherwise, we'll just be talking about it,
instead of having some
instead of
response.
having something concrete to react to, and then I would hope that could be a second draft that would,
Right.
and I
A
would
nearly
also,
final draft?
yeah, and I would also offer to provide some of the sort of introductory,
Sentences
one or
or
two
two.
sentences to each category that kind of explains why these matter.
Life is good. Yep.
We like this suggestion very much.
Yeah, I'm just having an idea of like the every other Thursdays reeling into this forever.
No, that's exactly my sense, and I was hoping that your
Meeting on
suggestion
Christmas.
might be made. So
That's
I'm
okay.
Or
very happy
Thanksgiving,
for
that's a
it.
Thursday, right?
Well, I
So
played
this-
right into your hands.
Yeah, you did, it's great. So, and so any help that any one of us can offer,
Happy to do that.
send something in, but what I want to resist is having a meeting by email. I think that's the worst possible
I
scenario.
totally agree, and
Yeah,
I'm not
so
suggesting that.
we don't do that. That's not
No
what we do.
hydroponic.
No, right, thank you.
Yeah,
I'll try to stay
drive
under
safely.
80. Thank you. Sorry, I'll
Sorry.
stay under 65.
Mhm.
See, thank you, Stephen. I'm gonna be under 65 the whole trip, I promise.
Good thing.
Thank you all, and I'm
Thank
sorry to
you.
leave
Thank you.
early, but.
No, but it's very helpful.
Same here.
Okay, good. All right.
Feel free to weigh in on anything